long these individuals knew Jesse?
No, I did not.
Nowhere in this X report does it say how well they knew Jesse.
Well, it says that they were his teachers, his babysitters, and his former playmates.
Nowhere in your X report do you document how well each individual knew Jesse.
How well, I guess not now.
You don't mention how much time any of these individuals spent with Jesse.
No, I did not.
All that information is unaccounted for.
It's not unaccounted for, it's just not in my report. I did make available a list of the names of the individuals that I reviewed, so if you would like to ask them how long they've known Jesse and how well they've known Jesse, that was available to you.
No need, Dr. Couples. Now, one of the traits that you used, that you studied, was persistent aggression, right?
Yes, that's correct.
Now, you gave Jesse 2 out of 2, meaning it's clearly present, right?
Yes, that's correct.
Now, you reviewed the affidavit of Danny Brooks, right?
Yes, I did.
Danny Brooks was the babysitter for Sydney and Jesse throughout the entire summer of 2010?
That's correct.
Now, from that affidavit, you're aware that Jesse would never hit Sydney one time?
Yes, that's correct.
Never kicked Sydney one time?
That's correct.
Never threatened Sydney in any way throughout that summer?
Never threatened her physically, but what Danny Brooks said was that Jesse was a bully to Sydney. So he was persistently aggressive verbally, not necessarily physically.
Well, let's get more specific.
Sure.
One instance throughout that entire summer, Sydney had actually pushed Jesse onto the ground. Isn't that right?
Objection, Your Honor. At this point, I'd have to object to hearsay. Dr. Couples' testimony is about Jesse Duran, and any evidence that is otherwise inadmissible that's helpful in explaining her conclusion for Jesse Duran is admissible. But at this point, we're getting outside of the scope of Dr. Couples' expertise, and I would have to object to hearsay.
May I respond, Your Honor?
You may.
The witness has just stated that she reviewed the affidavit of Danny Brooks, the babysitter, and coming to her conclusions in today's trial. Now, it's relevant for the jury to hear how Jesse reacted once Sydney had actually pushed Jesse onto the ground. If Jesse acted violently or didn't react at all. It's important for the jury to hear this when assessing the score that Dr. Couples gave Jesse.
Your Honor, if I may be heard.
You may.
Though Dr. Couples did rely on Danny Brooks' testimony, she is not allowed to be a conduit for hearsay, as stated in case law. Therefore, this line of questioning is asking her to do so because it does not directly go to her conclusion in this case.
Your Honor, if I may,
You may.
my contention is that it directly goes to the witness's conclusion. The witness has concluded that Jesse clearly has the personality trait of persistent aggression. This event goes to attack that conclusion for today's trial, and therefore I'm allowed to introduce this evidence.
Okay. The objection is overruled. I believe that it does go to the conclusions that she came to in the report, so I'm going to allow the testimony.
In one instance, Sydney had actually pushed Jesse onto the ground. Isn't that right?
That's correct.
Now, when Jesse got up, Jesse did not punch Sydney.
Not in that instant, no.
Jesse didn't kick Sydney.
Not in that instant, no.
You found no evidence that Jesse attacked Sydney in any way.
Not in that instance. However, in the disciplinary report, I don't know who the other students were.
But the answer to my question is no. Jesse did not react to Sydney in any way throughout that summer, in this instance.
In that instance, yes, that's correct.
So, had Jesse scored a 1 on his personality trait, he would have gotten an 11 out of 20. Isn't that right?
He wouldn't have scored a 1 because of all of the incidents in which he was aggressive towards other children and because of the document, Me and My Gun, which shows his aggressive desires, I guess
Dr.
you would
Couples,
say.
I'm sorry, maybe my question just wasn't clear.
Sure.
My question was, had you scored Jesse a 1, Jesse would have received an 11 out of 20, right?
If I had, but the evidence didn't warrant a 1, it warranted a 2.
Had you scored Jesse an 11 out of 20, he would fail the test, right?
Failed, if you mean he wouldn't have been a psychopath. I would probably
The test would
characterize
not-
as passing.
Your Honor,
The test would not confirm Jesse suffered from psychopathy.
Yes, that's correct.
Your Honor, I've got no further questions at this time.
Any redirect?
Yes, Your Honor. Dr. Couples, opposing counsel talked to you a lot about your psychopathy assessment instrument implementation on Jesse Duran. Can you tell us what factors went into the 2 rating you gave Jesse Duran?
For the persistent aggression?
Yes.
For the persistent aggression, I reviewed the student disciplinary report, which stated several instances in which Jesse was kicking, biting, and pushing other students. There was also the incidents involving the cruelty to animals, and the document Me and My Gun, in which Jesse fantasized about using guns on other children and saying that he loves his gun. All of this clearly indicates that Jesse Duran has persistent aggressive tendencies and desires, and therefore he clearly received a score of 2 in that trait.
Dr. Couples, are you confident with the conclusion that you came to in today's case?
Yes, I am.
No further questions at this time, Your Honor.
Brief and cross.
You may, assuming you have time.
Dr. Couples, the score of 2 out of 2 means a trait clearly applies, right?
Yes, that's correct.
A 1 out of 2 means it sometimes or somewhat applies. Isn't that true?
Yes, that's true.
I have nothing further.
May the witness step down?
Yes, Your Honor. Now will you read your report?
You may step down. Who's your next witness? I'm sorry?
Permission to deconstruct the demonstrative.
You may.
Your Honor, the plaintiff calls Andy Park.
Andy Park, please have him stand.
May I proceed?
You may.
Please introduce yourself to the jury.
My name's Andy Park. I'm Sydney's mom.
Ms. Park, how do you know the Durans?
Well, I met Hayden at the hospital when her son Jesse was born. I just had Sydney 4 months earlier, and we bonded pretty quickly over being new parents. And we kept in contact over the years, and eventually, when Sydney was 5, we moved next door to the Durans.
And can you describe for the jury the relationship between Sydney and Jesse?
Well, when we first moved next door, Jesse was always coming over our house, but mostly because he needed a babysitter. And then gradually, as he got older, he started coming over more and more often so he could play with Sydney. So in the beginning, I thought Jesse was a blessing.
Ms. Park, what changed?
Jesse did. You see, one of the reasons that Jesse and Sydney got along so well is because they both liked playing video games. But as Jesse got older, he went from playing games like Pac-Man to just these violent shooting games where you do nothing but shoot hundreds of people.
Objection, improper character evidence.
Any response?
Your Honor, that's just for clarification about the particular character evidence opposing counsel is referring to.
Yes, they are using this to show conformity that Jesse played or liked to play violent video games and that behavior moved into August 18th. They're attempting to show conformity therewith, and this is inadmissible.
Your Honor, I would refer the court to the same case law that Mr. Williams brought up, Longstreet versus Floyd, that indicates that it's acceptable for psychological conclusions to be admitted, and they're not counted as improper character evidence. Furthermore, other case law maintained, Longstreet versus Floyd is a clarification, one of which, Your Honor, of Hamilton versus Walton. And Hamilton versus Walton explains that testimony about psychological conditions also isn't character evidence. Dr. Couples just laid out all of the traits that went into her expert conclusion, and this sort of testimony here about violent actions and tendencies corroborates those conclusions that Dr. Couples arrived at. For that reason, it's not improper character evidence, it's admissible as testimony about a psychological condition.
Your Honor, may I be heard?
You may.
This witness, Mrs. Andy Park, is not an expert witness. She is a lay witness. She is not qualified to talk about a psychological condition. This is inadmissible. She's not a psychologist or a psychiatrist and is not qualified to speak on this issue.
May I respond, Your Honor?
You may.
Longstreet versus Floyd does refer specifically to experts, but that's a clarification of Hamilton versus Walton. Hamilton versus Walton doesn't necessitate that testimony come directly from an expert witness, even if it's about a psychological conclusion. And this type of testimony, Mrs. Park's not saying with any definitive, she's not saying definitively that Jesse suffered from a psychological condition because she's not qualified to do so. She is absolutely qualified to tell the jury about her experiences that corroborate the conclusions Dr. Couples arrived at that aren't themselves character evidence.
Okay. I'm going to overrule the objection and allow the witness to answer the question.
Ms. Park, you were talking about the violent video games that Jesse would play.
Right, so Jesse just started bringing over these violent games where you do nothing but shoot hundreds of people. And I guess he was allowed to play those at his house, but I definitely didn't want them around Sydney.
And so what did you do?
Well, every time he brought one of those games over, I would tell him that he had to wait until he got home to play it and that he couldn't play it with Sydney. It happened so often it almost became like a routine.
And how would Jesse respond?
he would always get visibly upset. Not so much disappointed, but angry. And there was just this one time that I saw a side of him that I'd never seen before.
And can you please explain to the jury what happened?
Well, it was right after his 11th birthday, and he brought over one of his birthday presents, a particularly violent video game. I mean, just the cover of the box was enough to shock me. And so, as usual, I told Jesse that he couldn't play that until he got home, and he just lost it. He threw a fit.
Objection, improper character evidence.
Your Honor, I stand by the response that I made earlier, that this evidence goes directly to support specific traits that Dr. Couples outlined in telling the jury about the conclusions at which she arrived. For the same reason it was admissible earlier, it's admissible now.
And I'm going to overrule the objection. I'm not sure if it's on the basis that you've argued, but I just think that it's something she can testify that she observed. I don't know that I'm drawing any conclusions from that, but she observed him throwing a fit. So I'm going to allow the witness to answer.
I'm sorry, Ms. Park. Please continue explaining to the jury.
So he just completely lost it. He was screaming. I don't even remember exactly what the words were, but every word of it shocked me. But what was even more concerning was not so much the fit that he threw, but the way that he acted afterwards. It was almost like he was screaming until he was red in the face one minute and then perfectly calm as if nothing had ever happened the next.
Ms. Park, did anything else concern you about the relationship between your daughter and Jesse?
Well, as I said, I was really concerned about the fit, so I went to Hayden about it and told Hayden that I was really surprised by this behavior, but Hayden wasn't surprised at all. It was almost as if Hayden was used to this sort of behavior from Jesse. And at the time, Hayden told me that they were working on that sort of behavior, so I let it go. And I should have just been able to connect the dots.
Ms. Park, what do you mean by that?
Well, Jesse's temper, the violent games where you shoot people, his control over Sydney.
Can you explain to the jury what you mean by his control over Sydney?
Well, it seemed to me that Jesse had this ability to get Sydney to do things that she wouldn't normally do, things that she knew were wrong. I mean, she was just the perfect child. I'm sure a lot of parents say that, but she always listened to me and my husband, except for when Jesse was involved.
Can you give the jury an example?
There was one time I caught her going through our office desk drawer, and it was a rule in our house that she wasn't allowed to go in there. We had a lot of important papers. And when I asked her what she was doing there, she said that she was looking for one of those games that I had taken away from Jesse for being too violent. And she said that Jesse told her that she had to get it back.
Now, Ms. Park, if you were so concerned about the relationship that Sydney and Jesse had, why did you let them spend so much time together?
I wish every day that I hadn't, but at the time I thought I was doing what was best for Sydney. She was really shy and introverted and didn't have very many friends, and I thought she needed one, even if it was Jesse.
Now, Ms. Park, I know that this is going to be difficult, but I need you to tell the jury about what happened on August 18th. Can you describe the morning for them?
Well, the morning started out as just an average day until I got a call from our babysitter and he said he couldn't come over. And so normally I would let Sydney stay home alone, but I knew that Jesse was coming over that day, so I asked a neighbor to keep an eye on things while we were gone. And he couldn't come over and stay the whole day, but he said he'd pop by every hour or so to make sure everything was all right.
So what happened that morning?
I wasn't even gone an hour when I got a phone call from a police officer. He didn't tell me what happened, but when you get a call like that, you just assume the worst. So I dropped everything and raced home as fast as possible.
And what happened when you got home?
I just saw police officers and emergency vehicles everywhere. They were all up and down my street, all up and down the driveway. I still didn't know what was going on. I just knew that I had to get to Sydney as soon as possible. So I threw the car into park and just ran towards the house.
And what happened when you arrived at the house?
There were people everywhere inside. I felt like a stranger in my own home. I didn't recognize anyone there. It was like everything was just going in slow motion. Until I saw a small body laying on the floor with a white sheet. I couldn't do anything at that time. I couldn't even stand. I just fell to the floor and started screaming. And the next thing I remember, 2 officers were pulling me outside onto the porch. And that's when they told me what I already knew. That Sydney was dead.
Thank you, Mrs. Park. Your Honor, I have no further questions at this time.
May I proceed?
You may.
Good afternoon, Mrs. Park. I'm just going to ask you a few questions, and if you need a moment at any time, please let myself or Your Honor know, and we'll give you a moment, okay?
Okay.
Mrs. Park, to be completely clear, you are suing Miss Hayden Duran, correct?
Yes,
For the accident on August 18th,
because Jesse shot my daughter.
and that happened in your home
Yes,
with your gun.
yes.
I'd like to talk to you more about how the gun was stored on August 18th, 2010.
Objection, Your Honor, to relevance. Mars versus Washington, that's in the case law packet. It's on page 3 if you'd like to refer to it. Mars versus Washington documents a case that's similar to this one in some ways. It was a charge of intent, and the judge in that case ruled that any testimony that goes to show negligence on the part of the plaintiff, Mrs. Park in this case, is irrelevant because it has no probative value in that it doesn't make any fact in this case more or less likely with regard to Jesse's intent. How the gun, if I may make an offer of proof, opposing counsel is going to elicit testimony to demonstrate that Mrs. Park was negligent and that the gun was easily accessible. While the plaintiff doesn't believe that's the case, it's still irrelevant to Jesse's intent. How he got the gun, how easy it was to get the gun, makes no fact about Jesse's intent once he had the gun more or less likely. And Mars versus Washington is explicit in saying that evidence that's only relevant to that isn't admissible.
May I be heard?
You may respond.
Opposing counsel is completely incorrect. We are not using this for an affirmative defense of comparative negligence. We are saying that if these 2 children were interested in a gun and had access to a gun, it makes it much more likely that this was an accident and not an intentional shooting. If I may proffer, I'm going to ask Mrs. Park about her daughter's accessibility to both the gun and the combination to the weapon. And this is going to show that Sydney Park was the only child that knew about the access, or how to access the weapon. And this goes to show that it wasn't Jesse's intent in playing with the gun, it was Sydney Park's as well. And this goes to show that it is more likely that it was an accident and not an intentional shooting.
Okay. I'm going to overrule the objection, and you may proceed with your question and she may answer.
Yes, Your Honor.
Okay, and I'd like to speak to you more about how you stored your weapon on August 18th, 2010. Now, you stored your gun in a combination safe, right?
Yes, that's correct.
And you wrote your combination down on a piece of paper and stored that in a desk drawer in your office.
Yes,
Now, your daughter had access to this drawer.
yes,
On direct examination, you told us that your daughter actually went through this drawer in May of 2010.
yes, that's correct.
Now, additionally, you kept your gun in your bedroom, right?
In our
see.
closet bedroom drawer, yes.
And your daughter also knew that you kept your gun in your bedroom, right?
I believe she did, yes.
She said that she was sure that it was in your bedroom.
I heard her tell that to Jesse, yes.
Now, you said a lot about being concerned about Jesse's behavior on direct examination. But to be clear, on August 18th, 2010, you left Jesse and Sydney alone in your home with your gun, right?
Objection. Your Honor, at this point I renew my objection. The nature of that question clearly is designed to indicate that Mrs. Park was negligent. The wording, "you left them alone with the gun," clearly goes to, opposing counsel is clearly attempting to show that Mrs. Park was negligent. And again, that doesn't make it any more or less likely that Jesse acted with intent once he had access to the gun. Mars versus Washington is explicit and unequivocal in maintaining that that evidence is inadmissible.
Response?
I can rephrase. You did say you were concerned about Jesse's behavior,
Yes, I was.
but on August 18th, Jesse Duran and Sydney Park were in your home, right?
Yes.
And they were alone, they were unsupervised.
Yes.
No further questions.
Redirect?
No, Your Honor, I ask that Ms. Park be excused.
Ms. Parks, you may sit. Are you ready to call your next witness?
Yes, Your Honor. The plaintiff calls Jules Sebastian to the stand. Your Honor, before we proceed, permission to set up a court for the demonstrative?
You may.
Your Honor, I'm just asking, may I be allowed to move when they make use of the
You
demonstrative?
may. Good afternoon.
May we proceed?
You may.
Can you please introduce yourself to the jury?
Good afternoon. My name is Jules Sebastian.
What is your educational background?
I received my bachelor's degree in criminology from the University of North Carolina, and I received a master's degree in forensic science from the John Jay College of Criminal Justice. I then went on to graduate second in my class from the Midland State Police Academy.
And what do you do for a living?
Since 2010, I've been the lead forensic investigator for Breckinridge County Midlands. Because of this, I've received extensive training in all areas of crime scene analysis, including ballistics, blood spatter analysis, evidence collection and preservation, wound orientation analysis, fingerprint analysis, etc.
And Mr. Sebastian, how are you involved in today's case?
Well, I was contacted by Officer Dale Williams on the morning of August 18, 2010, to investigate the death of a young girl that I later identified as Sydney Park.
Now, were you provided with sufficient facts and data to draw each of your conclusions in today's case?
Yes, I was.
And did you use reliable principles and methods when drawing each of these conclusions?
Yes, I did.
And Mr. Sebastian, did you apply these principles and methods reliably to the facts in today's case?
I did. That's my job, and my reputation depends on it.
Now let's talk about your investigation. What happened when you arrived on the scene of the Parks home on August 18, 2010?
Certainly. Well, as procedure dictates, as soon as I arrived on the scene, I created a detailed diagram of the Park's living room where the body was found. Once I ensured that neither the body nor the firearm had been moved or contaminated in any way, I began to collect evidence.
And what kind of evidence did you collect?
First, I placed the firearm in an evidence bag to avoid contamination. I then swabbed the hands of everyone on the scene, as well as the furniture in the living room, for gunshot residue. I also collected the clothing of Jesse Duran and Sydney Park, and I took the fingerprints of everyone on the scene.
Did you collect any additional evidence after this point?
Yes. The next day, I attended the autopsy of Sydney Park, where I obtained the 9mm bullet that was removed from Sydney's skull. At this time, I was also able to obtain Sydney's fingerprints.
And what did you do with all of the evidence that you collected?
Well, I used standard methods in my field to conduct a gunshot residue test, a fingerprint analysis, and a wound orientation analysis.
Now, let's take those one by one. First, let's talk about gunshot residue. Can you tell the jury what gunshot residue is?
Certainly. Gunshot residue is composed of particles of metals that are expelled when a gun is fired. The distribution of GSR, or these particles, can determine how far a person or object was from the barrel of the gun at the time the gun was fired.
And what methods do you use to collect these GSR particles for testing?
I tested the swabs I took on the scene for the presence of barium, antimony, and lead. These 3 heavy metals are key indicator elements for GSR particles.
And were you able to determine if there was GSR present on anyone or anything in the park's home?
Yes. I found significant amounts of GSR on Jesse Duran's hands and shirt, especially Jesse Duran's dominant right hand. His right hand contained, excuse me, over 200 particles of GSR. His left hand contained only 25 particles of GSR, and his shirt contained approximately 75 particles of GSR.
Now, Mr. Sebastian, can you explain to the jury why that evidence is particularly relevant?
Certainly. This indicates that Jesse Duran's shirt and left hand were significantly farther away from the gun than Jesse Duran's right hand at the time the gun was fired. Now, this indicates that Jesse Duran's right hand was nearly or fully extended away from his body, like so, at the time the gun was fired.
Now let's talk about fingerprint analysis. How did you conduct your investigation on fingerprints present on the scene?
Well, fingerprint analysis consists of comparing fingerprints taken from a surface to fingerprints taken from known individuals. To gather fingerprints in this case, I dusted the gun, the shell casing, and the park's gun safe in the park home for the presence of fingerprints, and I compared these fingerprints to fingerprints I took from individuals on the scene.
Now, how do you determine if the points of similarity qualify a print for a match?
Well, there's actually no universal standard for qualifying a match. It's generally accepted that the more points of similarity, the stronger the match to a specific individual. It's generally accepted in my field that 16 points of similarity signifies an absolute match. But it's entirely entirely possible to find a match with less than 16 points of the similarity in the case of a partial print, where the size of the print precludes the possibility of having a higher number of points of similarity.
Were you able to find any fingerprints on the gun?
Yes, I found 4 fingerprints on the gun that met the 16-point standard. There were one print belonging to Sidney Park, one belonging to Andy Park, and 2 prints belonging to Jesse Duran.
Were you able to find any fingerprints on the shell casing itself?
Yes, I found 2 partial prints in the shell casing situated on opposite sides of the shell, like so.
And were you able to determine who these prints belonged to?
Yes, the prints were a 12-point match for Jesse Duran's right index finger and a 10-point match for Jesse Duran's right thumb.
And were you able to find any fingerprints on the gun safe?
Yes, I found numerous fingerprints on the safe, specifically an 18-point match on the interior handle of the safe that was a match for Sidney Park, 2 full prints for Jesse Duran on the keypad of the safe, and about a dozen fingerprints belonging to Andy Park, which is to be expected as Miss Park is the owner of the safe.
Finally, Mr. Sebastian, I'd like to talk about your wound orientation analysis. Can you tell us how you conducted this investigation?
Certainly. Wound orientation analysis involves looking at the body of the victim and analyzing the shape of the entry wound created by the bullet. In this case, I found that the entry wound was an oval rather than a circular entry wound.
And why is that significant?
Well, I actually prepared a demonstrative to help me explain the significance of my finding.
Your Honor, permission for the witness to step down to make use of the demonstrative?
You may.
This is the diagram of the Parks home that I created as soon as I arrived on the scene. Now, the characteristics of the entry wound that I analyzed indicated that the barrel of the gun was approximately level with Sidney's head at the time the gun was fired. Additionally, the oval shape of the wound indicated that Sidney's head was turned 45 to 60 degrees to the right of the barrel of the gun at the time the gun was fired. Now, this means that Sidney was looking away from the gun, most likely in the direction of the television located here in the corner of the room.
Now, Mr. Sebastian, what does all of the evidence that you collected tell us most likely happened on August 18th, 2010?
Based on my analysis of the evidence and my findings, Sidney Park was facing away from the gun, most likely in the direction of the television in the corner of the room. Jesse Duran's hand was outstretched away from his body, causing the bullet to enter Sidney Park's forehead, creating an oval-shaped wound.
Thank you, Your Honor. I have no further questions at this time. Permission to deconstruct the demonstrative if counsel doesn't want it.
I don't need it, Your Honor. Maisha Ishmael for the defense. May I inquire?
You may.
Good afternoon, Officer Sebastian.
Good afternoon.
GSR will fall on a person if the gun is discharged while it's in their hand, right?
That's correct.
So regardless if it was intentional or an accident, the GSR will still get on that person.
Your Honor, sorry to interrupt, but permission for the counsel to move so I can see the witness, please?
Okay.
Thank you, Your Honor.
If a person intentionally shot the gun or if it was an accident, if it was in that person's hand, GSR would get on that person.
That's correct.
GSR testing is very delicate, right?
That's true, but with proper training, it can be very effective.
And it's subject to many well-known limitations.
That's true.
GSR can transfer from person to person, correct?
In small amounts, yes.
So if an officer has a high level of GSR concentration on their uniform, it could transfer to another person.
Trace amounts can transfer to another person, not in the amounts that I saw on Jesse Duran, especially Jesse Duran's right hand.
And to be clear, Jesse Duran came into contact with many police officers before you arrived at the scene.
Objection, Your Honor. Speculation. This witness was not present on the scene as he is a CSI crime scene investigator. Therefore, he came on the scene after the incident happened, and when he entered the scene, he did not see any contact between the officers and Jesse Duran when he walked in on the scene. Therefore, he cannot speculate about whether or not there was physical contact between officers before he arrived on the scene.
I can rephrase my question, Your Honor.
Okay.
You can't tell us whether Jesse Duran did or did not come into contact with those officers before you arrived, right?
No, I don't know.
You also conducted fingerprint analysis at the scene, correct?
That's right.
And like you told us on direct examination, you found Sidney Park and Jesse Duran's fingerprints on the safe.
That's right.
And you also found Sidney Park and Jesse Duran's fingerprints on the gun.
That's correct.
If I showed you that fingerprint analysis that you performed on the gun, you would recognize that, correct?
Yes, I would.
Your Honor, I'm approaching opposing counsel with Defense Exhibit B.
You may.
I'm approaching the witness with the same.
You may.
Thank you very much.
Officer, you recognize that document, correct?
Yes, I do.
That's the fingerprint analysis that you performed on the gun on August 18, 2010. Sorry.
It's a diagram of the gun with the locations of the fingerprints I found, yes.
So this is a fair and accurate copy of the analysis you performed.
Yes, it is.
All of the fingerprints that you found on this gun met your 16-point standard, correct?
That's correct.
Point 1 was Sidney
Objection, Your
Park.
Honor. Facts not in evidence. The counsel is testifying to the specific points of this exhibit and who they belong to, and this exhibit has not yet been entered into evidence. I would just ask that they lay the foundation and enter that exhibit into evidence before testifying to the actual content.
Your Honor, at this time, defense moved Defense B into evidence.
Is there any objection to it being moved into evidence?
No objection, Your Honor.
Okay, it will be so moved.
Point 1 was Sidney Park's fingerprint, correct?
That's correct.
And point 2 was Andy Park's fingerprint.
That's correct.
Point 3 was Jesse Duran's right pinky finger, or right index finger.
Yes, I believe that's correct.
And point 4 was Jesse Duran's right pinky finger.
Yes, I believe that's correct.
Officer, you're familiar with how a gun is fired, right?